Any mention?
Please, Your Lordship. Lordship, I beg to mention item number 99 to 109, the connected transfer petitions. Lordship.
99, why?
209, Your Lordship.
109.
Where's RP General?
He's on his way, Your Lordship.
Honestly, we have to the court or to
He's
Shillong?
there, Your Lordship.
99 to?
109.
Yes, why?
Learned senior is not available, Lordship.
When?
But Lordship, subject Lordship convenes the next week or
Next week,
subsequent.
okay.
Yes.
Next week. In the prayer of Sunsa, on behalf of CTB unwellness. Yes.
Highly obliged, Lordship.
Okay.
May it please, Your Lordship. Your Lordship, I beg to mention item number 118, Your Lordship, 118. On behalf of the private respondent, Your Lordship.
I'm for the state a lot.
Yes, but Siddiqui.
Yes,
Any objection?
no objection, Your Lordship.
Private respondent.
Private respondent law.
Respondent 1-5, Your Lordship.
Who are they? What's the case about?
This is a
Upayukta.
seniority.
When?
After
weeks
2
or
weeks, Your
days?
Lordship.
Yes.
Apply a lot.
Much obliged. This is Your Lordship. Lordship, I beg to mention item number 122. Already inform the other parties.
Yes.
We can have it on after 2 weeks, Your Lordship.
Yes.
Can we have it after 2 weeks, Your Lordship?
Come after 1 week, my lord.
Your objection. Okay, 1 week.
In the meantime, let the interim order may continue till the next day.
Yes.
First, Lordship.
Yes.
May it please, Lordship. Lordship, I beg to mention item number 111.
Your
Lordship,
objection.
this is actually pension matter. Now GHDs, they already received the money. Now they can pay. Otherwise, it's nothing. Even
Lordship, I pray for 2 weeks time.
Why 2 weeks time? Because Mr. D told you to say 2 weeks time.
Lordship, due to some
everything is.
difficulties.
1 week. If anyway, we can issue direction.
Yes.
Lordship, similar prayer for item number 114, Your Lordship.
14. Who's there?
114, Your Lordship.
No objection.
2 weeks. Okay. Yes.
Must obey.
Item 120 also, Lordship.
No objection, my lord.
2 weeks.
Much place, Lordship.
Lordship, I beg to mention item number 121.
So,
Affidavit, we have to file affidavit.
What's relative with?
The state, because the matter went for mediation, then after mediation.
Order column.
This
Yes,
is a revision of pay matter, Lordship, the connected to other matter.
Yes, sir. Mr. Khan, the counsel for the state respondent submits that the matter had gone for mediation, which was unsuccessful. He prays that we allowed 3 weeks time to file affidavit, 2 weeks time for affidavit. Praise allowed. Yes, this matter next in order column.
Hello.
You shouldn't come in the hearing. Yes.
supplementary list item number 1.
My results. My lord, just now I have noticed, my lord, the MP order has been wrongly annexed. Lordship permits I may be allowed to withdraw with liberty to file a fresh. Just it has come to notice, my lord. The MP order was supposed to annex the MP order, wrongly annexed, my lord. Wrong order is
Why
annexed.
next wrong order?
Yes, that was that objection I was to take, my lord.
Yes, my lord.
That,
There was two orders, my lord.
Yeah, Mr.
With RS Mishra, with liberty.
Mr. R.S. Mishra, Leonard counsel the petitioner, please am allowed to withdraw the petition due to certain defects. He further please allowed to file afresh. Withdraw will be fresh. Yes. Matter stands. Rules on withdrawn. Yes.
My liberty is granted, my lord. Much obliged.
Yes, please.
Much obliged.
Item number 2.
presence may be recorded.
Yes, Mr. B.K. Singh's. This is note down. At present we have respondent numbers. Number?
Yeah, respondent, my lord.
Number what?
2 to 4.
2 and 4.
2,
Yes.
my lord.
Dr. N. Musika present for 1. Yes.
Item number 2.
Obliged, my lord.
Yes.
My lord, we on the
What is this?
third round, my lord.
Lordship, so far item number 8 is concerned, your lordship.
Oh, no, 1 second, please come again. 2,
8 and 11.
number 2, this is number 2. Number
8
and
11.
it's the same parties.
Same contract.
Same contract.
Same contract, different parties.
Yes.
But so far item number 8, your lordship, the pleading there is an incomplete narration of facts.
Number 8.
Mr. Ashok Klein, your lordship.
We take up along with 11, my lord.
Anything to what is the issue now?
My lord, as far as I'm concerned, my lord, the division bench upon the appeal being preferred by the successful bidder, my lord, had passed an order directing the tender committee to reconsider my technical bid, mine and another, Mr. Sen. So the tender was thrown open. And we were, my lord, supposed to be reconsidered after giving, my lord, our show cause and everything. Despite giving our show cause and then our explanation, the subsequent clarification given by the bank has not even been considered by the tender committee. And plus, my lord, on new grounds, my lord, they have rejected us on not signing certain documents which were, my lord, certificates, board resolution. My lord, we cannot countersign those documents. Those are original documents, my lord.
Okay, then Mr. Chareso. Same. You awarded a huge, a certain portion of the contract also.
My lord.
Then what happened?
My lord has set aside 75 and 25. Lordship has set it aside.
Yes.
Now, thereafter, my lord, the entire tender is scrapped by my lord order. Therefore, we were requested to withdraw the EMT.
The fresh tender was floated.
They were supposed to, my lord.
No, my lord.
Now,
Same,
before
No,
they
that
do that, my lord, just
judgment
complete.
passed by this honorable court has been set aside, your lord.
My
Set
lord,
aside and then fresh tender
I'll
floated.
come to that, my lord. When lordship has set aside scrapping the entire tender process, my lord, the department requested the party to come and withdraw the EMT. So my party withdrew the EMT with the expectation that fresh tender would be started. Now, no one filed a appeal within 30 days. And after the expired 30 days, my lord, the respondent who received 75 has preferred 3 writ appeal before the division bench, asserting that he entitled 75. Therefore, I was bound to file a writ appeal. I also filed a writ appeal challenging the order, and subsequently all the matter were taken together. And the learned division bench clarified, set aside the impugned order to the extent that the tender committee will give one more opportunity to those 2 failed candidates. However, the rest
Give opportunity again to the 2 rejected candidates.
2 rejected candidates.
That means
That my friend and Mr.
Nobis
Sivasis.
and Okay.
Mariam. However, made it very clear that the technical eligibility of my candidate and Dr. Musika candidate cannot be revisited.
That means you're qualified.
Yes, qualified. Stands qualified, madam. Stands qualified. At that point of time, then EAG make a submission that I have withdrawn the EMT
Yes.
before the division bench. But division bench looked the entire matter and passed that order that my technical eligibility cannot be revisited along with Dr. Musika's one. Now, thereafter, immediately I resubmitted that withdrawn EMT, the same EMT. It's not a new EMT, to take on record. Now, director, without placing my record, my paper before the tender committee.
So your cause of action is different now.
Therefore, my
Than the
lord.
others,
Yes. Now, therefore, without placing my letter to the DM,
So you see you've been wrongly denied.
my lord. And thereafter, my
And
lord.
you and Mariam.
There's another relevant factor here. Against the order of the division bench, my lord, I preferred an SLP. You also just have the order.
Yes.
Already you have gone to us.
So I had preferred an SLP against the order of the honorable division bench.
Give us the copy.
And then
Just have a look at the order. Learned Senior Counsel appearing for the petitioner made a statement that the impugned order says that the petitioner was represented before the High Court. It is not so. Neither has notice been served on the petitioner nor has he been served. At least in the next page. In such view of the matter, we grant liberty to the petitioner to file a review petition before the High Court within a period of 2 weeks from the date of receipt of the copy of this order. Liberty is also granted to the petitioner to challenge the impugned order in the event of the review petition being dismissed. Thereafter, I preferred a review, which has recently been dismissed again by an order dated 30 and 25.
by division bench.
Now, against this, we are just in the process of preferring another SLP.
SLP or
The second
see, liberties are granted to the petitioner to challenge the impugn order in the event the review petition been dismissed. Now your review has been dismissed, and so you
the
file.
original order of the DB.
So now all the order of the DB stands, and you have to file a appeal to DB again against.
Yes, sir. So this is a relevant factor. I have to bring it to your lordship's notice.
Yes, so it gets curiouser and curiouser.
And in his Asokla in your lordship, he also filed a clarification application.
So
Yes, your lordship.
yes.
He also filed an application for clarification, your lordship. That also has been rejected.
Yes, that one I'll show to my lordship in my petition.
Thus, the fact and company reject offer the petition on the ground technical ineligibility.
The next on the notice.
No, it hasn't been annexed.
It is. It is.
And the order of rejection has not been brought before the division bench.
So you file,
In the process, my lord. In the process.
and meanwhile the contract been settled with
Dr.
Mosika's
Mosika client.
But surprisingly, day before yesterday, my lord, my friend has submitted.
Yeah, I have. That order has been placed, your lord.
The work order set aside by my lord. They relied on that again and asked Dr. Mosika party to implement it.
December 2024.
So there is no.
Okay, in view of this fresh development, what are we to take? When's SLP being moved?
Everyone's give us 2 weeks time. Our SLP should be.
Matter will come after 2 weeks.
Then matter will come after 2 weeks, you know.
We'll pass orders then.
Yes. My lord, the
8 to
supply
8
order issued to the respondent should be, my lord, may be state.
Oh, yes, sorry.
In the meantime.
On there.
Then no status quo on the work orders have been issued. He said
It has been issued, your lordship. It has already been issued and supply has been. Material has already been supplied, your lordship.
No. That is incorrect. Without work order, fresh work order.
I am the supplier, he is the receiver, my lord. How do they know, my lord?
No.
who's the
Yes,
supplier,
he has placed the order.
supplying what, receiving what?
Supply order. Supply order.
But I am the supplier and state has received the supply, my lord.
Lordship, yes,
My lord, can you see?
Please, your lordship, yes.
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 My lord, can you see? My lord, reference supply work order for December 2024, where lordship has set aside.
There is no fresh work.
My lord. And hearing was conducted on 17 September.
Yes,
Lordship, this is, lordship, kindly see on the top,
Mr. Shulai.
22nd,
September 25. When is the division bench order?
25/8. 25/8. 25/8.
But
28/8, your lordship.
This order, if there's been a fresh appraisal of the technical bids of the parties, then it calls for a fresh, a fresh work order, a fresh
Lordship, yes,
expression that,
this is there.
Lordships may kindly see the date of Supreme Court order is 26th September, whereby the Honorable Supreme Court has directed that Mr. Sen's line cannot be technically.
I think
This
Mr.
is
Shulai be well advised to put things on hold, otherwise it might create complications for the department. As it is, it creates enough complications.
Lordship.
And remember that this is involves roofing sheets for supply to,
Yes.
BPL families who need shelter. And if this kind of game is being played and the matter is not transparent at all, that's why this court has set aside entire 10%.
Lordship, kindly see, there is a judgment of the division bench 28/8, your lordship. So that has been considered in accordance
with the committee to proceed in accordance.
Judgment passed by the
doesn't mean that after tender become considered. Where have this whatever order you produced yesterday said that on a reappraisal of the technical bids, is there any rejection of the technical bids or that they're unfit?
Lordship, so far, Mr. Carson,
where the minutes of the tender committee which revisited the technical bids?
September mentioned.
Then we'll place, your lordship. Then we'll place all those facts, your lordship.
Till then, lordship may stay this order.
We'll have it tomorrow.
But
not tomorrow, your lordship.
Tomorrow we can.
Let's come on Friday, your lordship. Tomorrow I have
2 o'clock or so.
Your lordship. Tomorrow I have personal difficulties, your lordship.
2?
Lordship, I have to attend
At 2 o'clock.
a funeral. For, one
today?
of my distant relative died, Your Lordship, in the village. So I'll have to attend the funeral, Your Lordship. Kindly,
Today at 2?
Lordship, I'm going tomorrow, Your Lordship. I'll not be back by 2, Your Lordship.
Today at 2?
Today at 2. He can produce.
Friday? Let it on Friday, Your Lordship. On Friday, Your Lordship.
It's absolutely private bargaining is going on.
They are not eligible.
Dr. Muska,
It's highly arbitrary.
If you know that is, even if not legible, whatever the process should be transparent.
It's transparent.
You cannot have a process which is, you know, and in view of the Supreme Court order, we don't want to seem to be acting, you know, going on overreach. Anyway, this list is 8 to 11. Counsel for the parties, Mr. N.D. Shurailan, AG, appearing for the state respondents, appraisal allowed to place relevant records with regard to the departmental tender committee hearing which was held for reappraisal of the technical bits of the petitioner's hearing, and also to clarify on the work order dated supply order date 22nd September 2025 issued by the Director of Housing, Meghalaya Shillong. Yes, just on Friday.
Highly applied.
It's got between you parties, yes. Pleadings are copies to exchange.
Highly applied.
Well, in the Lordship may kindly keep the matter in abeyance.
If they do anything, we'll see.
But they'll say they finished the work, implement the work. That is how they are doing.
We have tomorrow.
He is withdrawn from the race and then he comes to file a petition.
That was placed for division bench. And division bench passed an order.
He withdraws his application,
and he took chance, Your Lordship, when
whatever as they sow, so shall they'll reap.
Exactly.
So if they've sowed well, they'll reap well.
Yes.
They've not
If they
sown well,
haven't,
that's what I'm trying to say.
It.
They've not sown well, my lord.
So that's it.
all right.
Item number 3.
Yes.
Milord, item 3, 5 to 7, Milord, and 21 to 92 are SOP matter, Milord. Even in fact, item 3, item 5 to 7, Milord, 21 to 92.
One second. Item
3, 5 to 7, Milord.
5 to 7.
21 to 92.
21 to 92.
Or 21 to 98, Milord. 21 to 98.
And?
They are all SOP matters. Your Lordship may hear it at the end of the board.
Yes.
All right.
It's not entirely from 21 to 98. There are some of the matters.
Yes.
Yes.
I'll jump out of my.
It's not.
You just kindly, before the matter is taken up
Yes,
again,
we
you
will.
kindly
We will.
Lordship, in item number 3, interim order may be extended.
We will hear.
We will hear it now.
We will hear it now.
Yeah.
We'll hear it now.
After some time.
Item number 4.
May it please, Your Lordship. Lordship,
Yeah.
by this writ, Lordship, I am impugning the letter dated, Lordship, 31/10/2025, Annexure 6, page 29, Lordship.
Annexure?
Annexure 6, page 29. By this letter, Lordship, the respondent has called for a meeting, executive council meeting, Lordship. I'm impugning that letter.
This one's already been from in the news report since this meeting been cancelled, correct?
No, Lordship. I will come. I will satisfy, Lordship. The facts of the case is that the respondent number.
Why are you impugning this 29?
Lordship.
Mr. Sen, Lordship. He's impugning this 31/10/25 letter.
My lord, what he is challenging? He is challenging that one of the dean of my lord school
Can
of.
he challenge holding executive council meeting?
Well, he cannot. I'll just coming. My lord, what is the basis of his challenge? Basis of his challenge is one of the dean who was appointed without specifying any tenure. As per the statute, tenure is for 3 years. So he is saying that tenure is not specified, and he was appointed in 24, your lordships. The 3 years terms not yet completed. So you see how this dean who was appointed without specifying any tenure could have been included in the EC meeting. That is his grievance, my lord. My lord, even if we have not specified, my lord, he has not even completed 1 year. If the case was that he continued beyond 3 years, my lord, then he has a case. Now it is premature, your lordship.
Lordship, I will submit, Lordship. The facts of the case is that, Lordship, respondent number 4 was appointed as dean in the year 2017 up to 2020.
Okay.
Then again, the respondent number 4,
Which school?
Lordship,
School of
social science, Lordship, social science. So respondent number 4 was appointed for the year 2017 till 2020. Thereafter, respondent number 4 again was nominated as dean, so by the respondent number 1. Then
2024.
yes, Lordship. Then the statute do not provide for nomination. Then they have rectified. Then they the respondent number 1 again reappointed the respondent number 4 as dean of social science, school of social science. Now, Lordship, in that is annexure annexure 4, Lordship, page 25. Annexure 4, page 25, where the respondent number 4 has been appointed without specifying any period. Whereas the statute, that is statute 6, Lordship, it provides that a dean can be appointed only for a fixed term, that is for 3 years. Now, Lordship,
now see let's just get one thing straight. Now you are claiming that you should be the dean.
Lordship,
Is there any vested right?
yes,
In
Lordship.
any
Yes, that is
claiming that you support
yes, Lordship.
yourself
Yes,
in that
Lordship.
department,
Yes,
that I should be a dean,
yes.
or by
I'm coming.
seniority or by is
yes.
there any right?
Yes.
How?
Because, Lordship, the dean can be appointed.
Show where the ordinance or statute provides that.
Lordship,
that
I'm
CMO
coming.
should be the dean, or
Yes.
if one person serves 3 years, is not eligible for second term.
Lordship, the fact is that a dean can be appointed only on rotation basis. So once the respondent number 4 was appointed in the year 2017 till 2020,
So
2020, she cannot be reappointed.
So 2024, she or he was not the dean.
No. I was
Then
not.
who was then the dean at that point of time?
Professor Lordship, he has already retired also. One Professor K. Dev Burma.
Okay, he retired now. That
He
means
retired.
that
So
that
after
person,
his-
the respondent eligible to be appointed against the dean.
Lordship, then I was eligible. I was eligible to be appointed as a dean, but they have not
By
appointed.
rotation, that means they can't rotate back the same person. No.
No, Lordship.
Show where does it say that?
Lordship, I'm coming. Lordship, page 31, annexure 8. Statute 26. Whenever, in accordance with this statute, any person is to hold an office or be a member of an authority of the university by rotation according to seniority, such seniority shall be determined according to the length of continuous service of such person in his grade and in accordance with such other principle as the executive.
What is seniority list? Where does it say that to be an HOD, to be a dean of a certain school or a department?
Lordship, this is the convention as going on, Lordship. This is the convention,
Yes,
Lordship.
Mr. Sen.
This is 24 order he is challenging now, your lordship.
Anyway, yes, here Mr. Bidep issue notice. Who is respondent 6?
The Teachers Association, although there is no such rule.
Okay, heard Mr. Bidep issue notice. Mr. S. Sen present. Except on behalf of 1, 2, 3, Mr. S. Deb, except on behalf of the respondent number 6 performer, respondent notice issue to the 2 remaining respondents within 3 days.
My lord, only one thing if I can point out, my lord.
Common instructions.
Only one thing, small thing. This 5, my lord, why he is a dean of School of Economics. He doesn't.
Lordship, because I have impugned the notification dated 31/10/2025, annexure 5. So by same notification, the other respondent was also appointed. If I do not edit him as a party, then it will be barred by necessary parties, Lordship.
After 2 weeks.
Lordship, interim pair was there, Lordship, because Lordship,
you can't even make out a case for where you have a vested right. You're showing a statute which is very vague in regards to seniority list. Now, whether the other executive instructions that govern the entire, how
Lordship, the fact is that, Lordship, the statute 6 is providing only for 3 years, Lordship. All right, Lordship.
Yes, before any other bench. Yes.
Item number 10.
No, see, Mr. Pandit, I think when I was a long time ago that consulted me before any case, or even then, to avoid any misunderstanding. Yes, Mr.
Please, Your Lordship, this is an application for continuation of delay.
Yes, sir. MS case. This is MS case number.
Excuse me.
615. 15 in 2025. I took a nothing for delay. Yes, 274 days.
Yes, Lordship.
This application of condition of 274 days in preferring the connected first appeal. Stop. Next paragraph heard Mr. Singh issue notice returnable in 2 weeks. How many respondents are there?
Just one.
Notice issue sold within 3 days. This accordingly and so on. So.
Lordship, in the main memo, I filed a prayer to stay the impugn order.
If you even your appeal hasn't even entered the doorway, how
I'll
you
oblige,
to sit at the table? Yes.
I'll oblige.
Daily list item number 1.
May it please Your Lordship. Your Lordship, praying for some accommodation in this matter.
Mr. Sen was here just now.
Yes, Your Lordship, yes. Lordship, no objection.
Why is this matter not being heard?
Lordship, here I have challenged the maintainability.
I understand. They shoot 7I.
Yes. Lordship, I have provided some judgment, Lordship.
Yes, we've already heard you also.
Yes, Lordship.
Substantively.
After 2 weeks,
It's
Your
not very
Lordship.
matter today.
No, Your Lordship. Lordship, the interim order may continue.
Very convenient. Yes, next year you take time, we'll vacate the order. Okay. Yes, sir. MS Ibla appraised for allowed. Appraised for on a request MS Ibla due to personal difficulty of her senior arguing counsel. This is a matter after 1 week.
2 weeks, Your Lordship.
Item number 2.
You object? No objection.
Lordship, it's a long time, Lord.
Interim order continue.
I'll oblige, Your Lordship.
Yes.
Lordship, on 31st of October 2025, Lordship, an order was passed by the Appellate Tribunal for Electricity, Lordship, in a similar matter, Lordship.
Yes.
Hence, Lordship, we seek some time to examine the applicability of that order to our case, Lordship.
Yes,
Just
Mr.
2 weeks time, Lordship.
Mr. Saikia.
SJ Sakyal.
Yes.
At least my friend should disclose the appeal number.
What appeal number? What appeal is that?
What is the matter? At least
where's your local council?
And we should know, and then we can.
Where's local council?
Adjournment is.
You don't have local council.
Lord, I am appearing for the respondent commission. We have the copies of the order also, appeal order also.
No, where's?
Appeal has actually.
Where is the?
Yes, my lord. Now,
it was with your junior.
What?
Yes. My Thana, right. What does it say? Some substance? Yes.
The orders have been remanded back to the commission for rehearing. Some of the issues.
And they asked for 50%. Yes.
Lordship will examine, and then your Lordship this order.
Mr. S.J. Saikia, on behalf of petitioner, submits that in view of the order dated 31/10/2025 passed by the Appellate Tribunal for Electricity in similar matters, the matter may be adjourned for 2 weeks to enable them to study the judgment and applicability to the instant case. Stop. Accordingly, this matter after 2 weeks. Yes, we record the appearance of so and so for after also.
Item number 3.
Yes.
May it please Your Lordship. Your Lordship.
So joined a file.
No, Your Lordship.
Why? How many times you saw it?
Maybe 3, Your Lordship.
This is the
This will be the 4th time, Your Lordship.
4th time. The rejoinder closed. This is a matter for hearing. Yes.
Item number 4.
Yes.
Your Honor, the conducting counsel will be appearing through VC, Your Lordship.
We don't see any conducting counsel. What's the matter about?
Your Honor, this is regarding the selection and appointment, Your Lordship, in the Assam Rifles, Your Lordship.
Affidavits have been exchanged.
Your Lordship.
Dr. Mozika.
My lord, we've raised the ground of maintainability, my lord. Number one is coming after 5 years, my lord.
Yes.
Secondly, my lord, earlier approached Rajasthan High Court, withdrawn the without liberty, my lord, then they filed here, my lord.
Are you ready with the matter?
Yes, Your Lordship.
Are you ready?
Your Lordship, the conducting counsel.
We're not going to wait for conducting counsel. Are you ready with the matter or not?
Yes, Your Lordship. So, Your Lordship, then can it be kindly taken in the end of the board, Your Lordship?
No end of the board. You have enough matters list today. Are you ready, personally ready to the matter?
Not me, Your Lordship.
No, then, okay, we'll list it next Monday.
Okay, Your Lordship.
You tell your counsel to be ready.
Yes, Your Lordship.
And remember, it's on a maintainability ground.
Yes.
Much obliged, Your Lordship.
5.
In the absence of conducting counsel through VC, this is a matter on Monday. Yes.
In this matter, my lord, last opportunity was given to us to file the objection.
Yes.
But that was on the second day of the matter.
Second day of?
The second time, my lord.
It is the matter for hearing. In the meantime, Mr. Thapa is going to file a rejoinder. Yes.
Objection, my lord, to the.
Objection or rejoinder.
4, 5, 6.
4 and 5. 5 and 6, my lord.
5 and 6. Problem, Your Lordship.
7.
His Lordship, this matter can be closed, Your Lordship, because they have processed for payment. I also have.
His GST is still deactivated, Your
By
Lordship.
the council that the orders, the process have been complied with.
Yes.
This contempt action that is closed at this stage, yes, and disposed of.
Much less, Lordship.
8.
8. Report.
May it please, Lordship. Lordship, I pray for 2 weeks' time to file the affidavit.
Yes. Ano man akong 2811 hijau matter. Yes.
Lordship, I paid for 2 weeks' time to file the affidavit.
Since when was this matter filed? See,
it was filed on 23rd April 2025, Your Lordship. 23rd April 2025.
April not filed. What's the matter about?
Your Lordship, the separation of village, Your Lordship. Gamura matter, Your Lordship.
When can you file it?
After 2 weeks, Your
You don't have
Lordship.
instructions as yet.
Lordship, we have not received some clarification regarding the Paravai's comments.
You're holding the office now. You're presently in office. How many occasions have you been given time to file affidavit? Okay, further 2 weeks time is allowed to respond 1, 2, 3 when affidavit you file it.
Hello, Lordship.
9.
Yes, my lord. In this matter, my lord, I will take 2 weeks' time, my lord, to file by rejoinders.
Your Lordship, I'll file my affidavit on course of the day.
You haven't filed affidavit till now.
I'll file it course of the day, Your Lordship. And Your Lordship, regarding to the affidavit which I have filed on behalf of respondent number 9, there's oversight mistakes, Your Lordship, in the affidavit. So kindly allow me to correct the same, Your Lordship.
What mistakes? Are they curable or incurable?
It's curable.
Typographical or they are?
Yes, Your Lordship. It should consist of 19 villages, but I've stated
Harmi?
9 villages.
No, this is still Lordship. Variat?
No, Lordship.
No affidavit?
No affidavit.
6 to 8?
We already filed, Your Lordship.
13? Okay, MSF cuts Young Learner Council from 9 and 10 submits that the affidavit has one number 10 will be filed in the course of the day. However, she also praised that as there are some typographical errors in the affidavit file on behalf of one number 9, he may be permitted to correct them in the registry itself. Yes, the praise allowed. Stop then. MS Bank for the petitioner based on receipt of the other affidavits we permitted to file. Rejoinder just after 2 weeks.
Who's obliged?
10.
Please, Your Lordship. Lordship, we are not filing our rejoinder. Pleadings are complete, Your Lordship. As the matter goes for hearing.
Don't file rejoinder.
No, Lordship.
MS M. Rahman, the constitution submits that no rejoinder will be necessary. Stop, like, according to the matter for hearing, and so and so.
11.
Lordship, it's in the process
You
of
filed
filing.
it
Process of filing, Lordship.
today.
Yes, Lordship, or filed.
Then next week, Lordship. Next.
Next week, yes.
Next week,
MS,
your pension matter,
Prasad, the constable number 6. Pala, I file.
Because there is no denial, Lordship. They are supporting my case.
Yes, for 6 submits that the affidavit will be filed in the course of the day. Just after 2 weeks for rejoinder if any.
12.
Here, Lordship, I have filed my affidavit, Lordship. What transferred from the affidavit, my Lordship, because the someone has already been appointed in his place.
Who? Someone's been appointed in his place.
But that is his son, Lordship. The son of the petitioner has been employed. So now he is a necessary party, Lordship. If any order is passed, Lordship, now that will
Son of
direct.
the petitioner?
Yes, Lordship. Because here what happened, Lordship, the mother-in-law of the petitioner has donated a land, Lordship. Then in lieu of the land, then the department has employed the petitioner as a casual employee, Lordship. Now, Lordship, now the petitioner has left the family. Now the mother-in-law has written a letter to the department praying that the employment should be given to his grandson, Lordship. Then accordingly they have acted.
I'll just
So
take
then you have
instructions.
any grievance? Any your son's been given?
I'll just take instructions on that point, Your Lordship.
How old are you?
He has served 13 years as a casual employee.
39 years old, Your Lordship.
You're 39.
Yes.
So you don't need this job anymore.
I'll just take instructions, Your Lordship, whether I'll file rejoinder or not to the
You've
affidavit.
left the family, meaning you've
I'm not aware of that fact, Your Lordship. So I'll just
run
have to-
away.
Not aware of that fact, Your Lordship.
Not aware. Yes, Mr. S.A. Sheikh submitted that there has been development in the matter, and as much as the son of the petitioner has been given the appointment in place of the petitioner. In place of the petitioner.
In place.
Because the petitioner stopped Mr. Parsons is allowed to obtain instructions allowed less after 2 weeks. Yes.
13.
Affidavit filed?
Yes, Your Lordship.
Yes, Mr. Sheikh.
Lordship.
File
yes.
rejoinder?
No, Lordship. Rejoinder is not required.
Reported for hearing?
Lordship.
Yes, Mr. S. Sheikh submits that no rejoining necessary for his post matter for hearing and so and so. Yes.
Must.
14.
Here I have received the parawise, so I'll pray for some time.
You receive meaning?
I received the parawise comments, madam.
What's the matter about?
This is regarding regularization and payment of salary, payment of pension, my lord. Earlier,
you're retired now.
Yes, Lordship. There is earlier a similar situated person. They have been regularized and from this court only, and they have paid a salary also from this court only. There are many judgments I have enclosed it also. This is regarding the appointment of DH school.
Yes, 1 week's enough.
My lord, since it's from Garwals, my lord, I'll pray for
Garwals
He said
is
he
this-
already received the parawise comment and he's saying.
How do you give Paras comment? We'll dispose it of. What does the Paras comment say?
My lord, it has to, it's await the finance pay revision approval will be necessary, my lord.
For revision?
Yes,
Yes,
because his
regularized.
appointment was ad hoc and temporary
Now,
appointment.
when was his appointment made? Before 2007?
His appointment was made into 1990, my lord.
Then it should be no impediment. What do you have to say?
So that is why, my lord, kindly allows me some
You
time.
just give a time frame for completion and dispose of the matter. Or you want to file an affidavit? There is nothing an issue if that's the only
10 days time
instruction you have. Yes, you file affidavit, then 2 weeks time that's clear out. There is nothing there. You will save the bother of drafting affidavit also.
15.
Most blessed Lordship.
Your Lordship, the state respondent has filed the affidavit.
May I please, Your Lordship? We require another 2 weeks' time, Your Lordship, for filing the rejoinder, Your Lordship.
Private respondent also is fine.
2 weeks time for journal the affidavit filed by the respondent.
Much obliged, Your Lordship.
16.
That's clear.
Complete madam.
My lord, we have filed a miss case, my lord, to implicate the original owner, my lord, of the land who.
Any objection?
Lordship, then this will culminate into a civil suit, my lord.
Let it go through the process then.
Yes.
Once you let them, you are who?
My lord, I am the person, my lord, who is aggrieved by an order of the Deputy Commissioner, my lord, and because
this matter, the suit's already been decided.
the suit is pending, my lord.
Pending. Then
Pending,
please
Lordship.
help there.
So it's sub judice.
No, my lord, I am only agree with the order of the Deputy Commissioner, my lord. I'm only against that order, my lord, I have come. So last occasion, my lord has asked me to implicate the original owner. Yes, my lord.
Lordship, this is because of the pendency of the title suit, Lordship. How
My
can
lord,
construction go on, my
Doesn't
lord?
matter. Yes. The more the merrier. You have objection to impleadment? Then you put on affidavit then.
That will be better, Lordship.
And in this case number 2020-2025, and so on, so an application on behalf of the petitioner to implead two respondents, two persons who are said to be the original owners of the land, namely, one Jukan Kurkalang Se and two Samiti so and so Kremlin Kurkalang Se. The same objected to by the then advocate who prays was allowed 2 weeks time to file put objections on affidavit. Yes.
Much obliged, Lordship. 17.
Here we have filed a miss case, my lord, to implicate the successful candidates, my lord.
Have you got instructions with
The MPSC is supposed to.
We cannot provide the address of all the successful candidates in Lordship. So Lordship, at the time of registration with the Commission, when they provide the details, we have given them a condition that their details will be protected with the Commission.
They can serve the copy. They can, if they do not give us the copy, my lord, it can be served through them, my lord.
Lordship, there is another way of issuing notice, actually, Lordship, through public notice.
Well, I'm ready for that also, my lord.
Yes, MS BF Kramanlang today submits that due to unavailability of the addresses of
the successful candidates.
successful candidates. The details cannot. The spot number 3 is unable to provide the details. On this submission page, without to issue public notice through newspaper, it is allowed. Yes.
Obliged.
For further orders. You produce newspaper.
My lord.
18.
Yes.
Step has been taken upon the respondent number 2, 3, 4, and affidavit also have filed in proof of the service.
I don't know, appearing for 2 to 4.
I think AG
2 to 4 whom?
AG is appearing.
2 to 4. Which response are these?
Somebody is there in the standing council.
Somebody is there. This is
AG is there.
Yes, MECL.
MECL, yes.
MS Kolni.
Yes.
Is that by execution?
Yes.
What is a pay?
This is regarding the notional increments.
Why not acceptable? Why is this? This hot and cold kind. In some matters they stand up, receive notice. When the matters move, other matters they say we don't have any instructions. They don't have a panel of counsels representing them. MECL doesn't have. They'd be well advised to have.
Yes.
There is a more litigation that's there.
I'll inform the
It's called
regional
Advocate
body.
General. We'll issue directions. Yeah. Now putting litigants to unnecessary difficulty. The Advocate General is seen in some matters, MECL in the court itself, MECL accept notice. In some matters now, they say
No, I will.
no, not the thing that is well advised if they put a panel of some standing counsel. Now this is a matter they've served, the affidavit has been filed, no one's appearing.
Last date also nobody appears.
I'll look into the matters, my lord. I'll examine this. I'll sit with my friend. I'll find out.
Yes,
Who has filed it?
the learned Advocate General today has undertaken that the representation shall be made on behalf of response 2, 3 and 4. Who those served and affidavit filed has not entered appearance today also. Just after 2 weeks for instructions affidavit is.
Yes.
Otherwise we have
I'll take a step.
we have a
I'll
panel.
take.
Some matters they are up and running and other matters they just
I'll take a step.
come to small matters of some person demanding the
we will appoint some
entitlements. Yes.
appoint some standing counsel.
Only when
so
it comes to big matters, then we have a whole
I
battery
understand.
of lawyers
My lord.
standing.
Yes, my lord. We will. I will take a step.
It is your lordship.
You corrected the mistakes now.
Yes, lordship. Miscase has been filed. It will be listed tomorrow, lordship. So I pray that the matter may come up along with the miscase.
Miscase has come to 288.
Yes, lordship.
It's already here.
What's the apologies?
You have no
lordship.
objection. Complement.
Application.
There is an application for impleading the Khasir Council response.
We have no objection, lordship.
And amendment cost titles also. There is no objection from the side of the respondents. Finding the miscase is allowed and the chief executive member. What chief executive member?
It's lordship. Those were my instructions, lordship. CM and the deputy secretary.
Actually, it is dependent by the secretary only.
Yes, lordship.
You should not be chief executive member. Then he won't send you back for correction. Just write the
apologies, lordship. I'm grateful for the
to the secretary and the deputy secretary should be respondents number 4 and 5. Registered to be necessary corrections. Not CM. CM is a political code.
Much obliged, lordship.
Lordship, I have an additional prayer. If I may be allowed to take fresh steps on the performer respondent, which is the
main
CM
case,
of Nongha.
the main case,
Too dusty.
petitioner prays allowed to take fresh steps on the performer respondent within 3 days. Just after 2 weeks for further orders.
Deeply obliged.
Much obliged, lordship.
20.
Please, Your Lordship. Lordship, I pray for a week's time, Lordship.
What's the matter about?
Cancellation or termination of the petitioner contract.
Cancellation of? Oh, that software matter.
Software, Lordship. Trading license.
Trading license?
Lordship.
For printing trading
Printing
license?
of trading license.
No objection to 1 week for the time. Yes, I've prayed for the 1 week's time allowed. Let's respond to that affidavit.
21.
Highly obliged, Lordship.
Hmm? 21.
The SOP matters, my lord.
The
But what
357.
357 from supplementary list, my lord, and give a chart. My lord, right from 21 till 98.
Yes.
These are all except my lord 93, 94, and 95. I am not aware what are these matters. 93, 94, 95.
Up to
21.
Till 98, my lord.
Yes. Except
93, 94, 95, my lord, I will represent.
93. They are part of the same matter.
Same SOP matter only.
Well,
So you're not appearing in those matters only.
no, well.
Otherwise, three matters, Mr. Sama's appearing.
My lord, apart from that, my lord, 50, 51 is Mr. Pandey's matter, my lord. 50 and 51.
83 also.
83. 86, 87. Yes.
I want to see. Huh? Because this bench has to break for a decision bench. You know? So, yes, sir. 87 who's appearing? Mr. Pandey.
Lordship, I am appearing in item number 50, 51 and 83. Lordship.
Then who's appearing 86, 87?
Mr. Pandey's matter.
86, 87.
Mr. Pandey's matter. 86.
Where Mr. Pandey?
I applied.
Yes, okay. You bring 50, 51, 83, 67, 94, 95 is PT Sangma, and the rest all your matters.
93
5 and 7. Today 3, 5 and 7, Mr. Debs.
Lordship, from 3, only item number 3, Lordship, from supplementary.
Number 3.
5, 6, 7 I am saying.
So lion's share is yours.
Because you file individually, my lord. That's why many of the cases file individually.
No, I mean, I'm just not thinking.
Number wise,
It's not share that way. Yes. Shares 21, right?
Give me the list of books. But before coming to the facts individually, my lord, your facts are different in every case, my lord. So I'll just place the evolution of law, my lord. Recently, what is happening?
We look at the bigger picture first. That brass tacks is on.
My lord.
No, not 438. So we'll consider 438 the lead matter. Okay.
First matter is.
Well, 4 may not serve as a lead matter because what happened, my lord?
438.
438, my lord. Because what will happen, my lord?
Affidavit has been filed in 438. Issue is common in all that.
No, issue is not common. The facts are very different.
No, not the facts. I'm talking the point in issue regarding the. You're challenging the SOP. All the case. That's the central issue.
But only one thing I'll submit in the beginning, my lord. Especially the cases of ANM and GNM, my lord.
They're different.
Because we have made a specific prayer to exclude them from the purview of SOP because they have been regularized, even confirmed, my lord. And there is one case where given promotion also, my lord.
So you give the numbers of those cases.
That is item 92. If
so you give the WC number. You treat that
item
separately.
92. Sorry, 96.
So WPC number?
96. WPC number 554. As per chart given by Dr. Mojika.
554.
556. And 559. Am I right?
Only 3 matters.
3 matters.
Yes, my lord. And some matters are coming on 18th, my lord. Of nurses. Those are listed on
18 meaning?
On 18th of
Other
November.
cases are coming on for hearing.
Some cases are coming
today only these 3 cases as per Dr. Mojika.
So today, then what are those representation numbers?
Number is 554.
Given the chart, my lord, you can correlate from the charge.
554, 556, my lord. GNM and ANM.
Let's be clear on the.
Lordship, kindly come to the last page, my lord. Serial number 96.
96 is the representation number. 556.
554, 556, 559. Yes, then.
Even paramedics will fall in that category, my lord.
567. Then that's it.
91 and 92 also, my lord. Serial number 91 and 92. Paramedics.
Yeah, that's already noted. 557 and 558. So these matters segregate them. Okay, I'll just give numbers 554, 556, 559. Wait, what? 554, 56, 557, 558, 559, and 567.
567, my lord.
Ayo, 54, 56, 57, 58, 59, and 67. We fix 5. Yes. Okay, that will segregate. Yes, beat them differently. The rest we will take up. Yes.
Now, coming to the compilation I've given, my lord. List, yeah, list. Put the list of the list is given. Dr. Mojga has given the list of judgments on which he is placing reliance. Where is the chart? No, the list of judgment. But first judgment I'll refer to is Jago versus Union of India. This is mine. They decided on December 20th, 2024. They are relying on their judgment. I'll take a lordship to para 10. Ask 12. Get me mobile.
Yes.
Para 10, my lord. I'll take para 10.
This is 24.
This is December 24, my lord.
Yes.
Para 10, I am ready, my lord. Having given careful consideration to the submissions advanced and the material on record, we find that the appellant's long and uninterrupted service for a period extending well beyond 10 years cannot be brushed aside merely by labeling their initial appointments as part-time or contractual. The essence of their employment must be considered in the light of their sustained contribution, the integral nature of their work, and the fact that no evidence suggests their entry was through any illegal or surreptitious routes. Para 12, my lord. Despite being labeled as part-time workers, the appellants performed these essential tasks on a daily and continuous basis over extensive periods ranging from over a decade to nearly 2 decades. Their engagement was not sporadic or temporary in nature. Instead, it was recurrent, regular, and akin to the responsibilities typically associated with sanction post. Moreover, the respondents did not engage any other personnel for these tasks during the appellant's tenure, underscoring the indispensable nature of their work.
Yeah.
Now, I'll
conclusion.
Now, para 19 onwards, my lord, there's the conclusion of the.
Yes. How does it distinguish it, Umay TV?
My lord, the distinguish, I'll point that out, my lord. In para 20, in this judgment itself, my lord. Para 19, I'll read, my lord, first.
Yes.
It is evident from the foregoing that the appellant's roles were not only essential but also indistinguishable from those regular employees. Their sustained contributions over extended periods, coupled with absence of any adverse record, warrant equitable treatment and regularization of their services. Denial of this benefit followed by their arbitrary termination amounts to manifest injustice and must be rectified. It is well established that the decision in Umadevi Supra does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumentalities. That said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular and where employees have served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and humane resolution becomes paramount. Prolonged, continuous and unblemished service performing tasks inherently required on a regular basis can over the time transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar versus Union of India, it was held that procedural formalities cannot be used to deny regularization of service to any employee whose appointment was temporary but has performed the same duties as performed by the regular employees over a considerable period in the capacity of the regular employee. The relevant para of the judgment have been reproduced below. I'll just read the quoted part also. The application of the judgment in Umadevi Supra by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetuate, deny substantive rights that have accrued over a considerable period through continuous service. The promotion was based on a specific notification of vacancies and a subsequent circular, followed by a selection process involving written tests and interviews, which distinguished their cases from appointments through backdoor entries, as discussed in the case of Umadevi Supra. The judgment in the case Umadevi also distinguished between irregular and illegal appointments, underscoring the importance of considering certain appointments, even if it were not made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they had followed the procedure of regular appointments, such as conduct of written examination or interview, as in the present case. The High Court placed undue emphasis on the initial level of the appellant's engagement and the outsourcing decision taken after their dismissal. Court must look beyond the surface labels and consider the realities of employment. Continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their appointment. In that light, refusing regularization simply because their original term did not explicitly state so, or because an outsourcing policy was belatedly introduced, would be contrary to the principles of fairness and equity. Then it goes on, my lord, para 23, I'll refer, my lord. The international labor organization, of which India is a founding member, has consistently advocated for employment stability and fair treatment of workers. The ILO's multinational enterprises declaration encourages companies to provide stable employment and to observe obligations concerning employment stability and the social security. It emphasizes that the enterprises should assume a leading role in promoting employment security, particularly in context where job discontinuation could exacerbate long-term unemployment.
Okay.
Para 26, my lord, is towards the conclusion, my lord. While the judgment in Umadevi sought to curtail the practice of backdoor entries and ensure appointments adhere to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate rights claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in regular appointment who were engaged in fully sanctioned posts and have served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of the employers, even in cases where the appointments were not illegal but merely lack adherence to procedural formalities. Government departments often cite the judgment in Umadevi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of the cases where regularization is appropriate. Thus, selective application distorts the judgment's spirit and purpose, effectively weaponizing it against employees who have rendered indispensable service over decades. In light of these considerations, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment, engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization's function, not only contravenes international labor standard but also exposes the organization to legal challenges and undermines employees' morale. By ensuring fair employment practice, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principles of justice and fairness and that they are meant to embody. The approach aligns with the international standards and sets a positive precedent for the private sector to follow, thereby contributing to the overall betterment of labor practice in the country. But in conclusion, my lord, the direction was issued to regularize the service.
Sorry, but we'll have to resume.
We'll resume.
Yeah. Because even the judgment, I think Dharam and
yes,
Vikramat has taken,
yes, my lord. The second judgment is Dharam Singh, my lord, and thereafter there are some more, my lord. I'll place all this. लिस्ट से हो जाए कॉपी हो जाएगा
22? 22?
I think where's Advocate General?
21.
There'll be a dislocation. I think there's some bar function 130.
At 1:30.
Personally, I think we better put it tomorrow. We can have, we're going to have it at length, and I don't want to keep it pending also. What do you all suggest? Yes, I think there's some bar function 130.
Yes, 1:30.
We'll put it tomorrow. Then this matter we can hear it.
Yes,
we can give you enough time.
Yes, ma'am.
Yes, just these matters for further hearing tomorrow.
Only that A&M and GNM, the other matters are coming on the 18th.
Let all mothers come, my lord, and then we'll
hear them separately. Because only thing is that we'll hear. See, the central issue is this SOP that is issued, and their rights that whatever.
Yes, madam.
That is one part. Some uniformity is there because they've been serving for over 10 years. Correct.
Yes.
All of them are over 10 years.
Right.
Yes, madam.
And they're continuing in service till today.
Yes,
the other part is with regard to how they're situated, in the sense that they've all been regularized, they've been given promotion, they've been given other service benefits, and so they have been taken apart. And so if suppose they succeed here, then it's
I understand.
Otherwise, if they don't succeed, I mean, if we hear them separately, then if we feel that they have to be treated differently, we have to treat them differently.
The core issue your lordship has correctly identified is that whether they have right to get themselves regularized or not. So that is a core issue, and some of these judgments which my friend is citing is saying that they have continued for some period of time, therefore they have a right.
Because see, the laws. Yes,
I will
as
cite,
usual in service law, it changes every day. The thing is that now what they'll have to satisfy the court is that you can distinguish what has been given Umar Devi, like where they've come irregular appointments, not illegal, and that though they've come in through the back door, that is,
back door has they have to go by back door only.
Process, but they should go a back door, or they should be.
Yes,
yes. But one aspect, my lord, A&M, GNM people and Advocate General can have specific instruction, my lord.
No problem. We'll
segregate them.
Whether SOP covers them or it doesn't cover them. We will take that. We'll go into that issue tomorrow also.
We'll not mix it up. I mean, just these matters are on one plank.
Yes.
That's not. This is one page. That's not a different page.
But there will be, in fact, 3 categories, my lord.
No, we will. So when we go,
I'll just clarify. A&M, GNM, who were selected through advertisement, my lord, sent for training.
No, my lord. That I have dispute because.
Let me make submission.
Yes. One category of A&M, GNM, and even paramedics, my lord, selected through advertisement, sent for training, executed bond, my lord, regularized, confirmed in service, with all service benefit, my lord, service book. So that's one category, my lord. Second category is in other departments also, my lord. For example, weaving and sericulture department. Again, there are technical posts, my lord. Weaving inspector, weaving demonstrator, sericulture demonstrator. They are very highly skilled corps, my lord. So they were also selected through advertisement, sent for training, my lord. On completion of training, executed bond. Again, same process followed for them also, my lord. So this will be second category, my lord. Apart from health department, sericulture and other department also, there are some posts like that, my lord. And third will be
now, Mr. Advocate General.
Yes, my lord.
Suppose they fail to succeed. Now they've been given this kind of livelihood, which they sustain their entire families from.
Yes.
So through employment now, what will be this? What will be the consequences?
I understand, my lord.
I'm talking about a human consequence.
Yeah, human consequences. Equity. What
happened? What happened to them? Suppose a person been working for
15, 17
years.
My lord,
better that income.
no, my lord. Yeah, I understand that.
Yes.
That's a human problem of the entire issue, my lord.
So whether you have plan B,
no, we will
from the state government. Whether
we can,
these people suppose they can't be accommodated. Suppose these posts have have to go for selection. Whether they can,
and they are getting
any plan B where they can
no,
be
Lord,
accommodated and not be
no, my lord. Similar and identical cases have come before the Honorable Supreme Court, where the Honorable Supreme Court has molded some of the issues, my lord, which is because I understand
that's why this court also examine all the
aspects, my lord. That something can be molded and can be accommodated, but the question ultimately is, my lord, that they are coming right from very first day. Their appointment was
We
temporary.
have to prevent that.
Yes,
See,
my lord.
that is onus is on your own
Me
departments,
and
where you have accommodated them, you pointed through a back door, allow them to serve.
and there is no advertisement. There is no advertisement, my lord. I will show that there is no advertisement, and they have been appointed temporarily for and with the rider that your appointment is for limited period. I understand that there is a, but at the same time they can. We have given the age relaxation to them. They can appear in the examination.
Well, some
they
asking,
but they are asking.
Okay, let us, me and advocate shall go and appear LLB exam now.
No, I can pass it.
I'm not very sure whether I'll pass it today.
Me too, I can pass it.
Okay, let us wait then. Who can answer 10 questions first?
And the state has already set a precedent, Lordship.
I will demonstrate.
Recognizing similarly.
Yeah, I will place it.
7 in 2022, Lordship.
No, see, Mr. Pani, that is why this court is saying whether they have a plan B. That's all. We'll examine it, the law
all issues are
as it
thrown.
applies now, all issues. Yes. We'll give you a fair hearing.
Yes, yes.
So also because you see, anyway, public employment, we will. Yes, we'll have it tomorrow.
Yes, my lord. Yes, grateful.
For other hearing matters.
Hearing number 10.
Tomorrow, anything?
My lord, this matter was previously heard, my lord. No, this is KP. My lord, pursuant to the hearing, your lordships had sought some clarification from the state, my lord. And they have filed an affidavit, my lord.
This is regarding contract?
Yes, my lord. Dues, my lord. An affidavit was filed on 5th of June 2025 by the state. I've gone through the affidavit, my lord. Even I could not understand. So
Where is that?
the council will. This is filed on 5th of June 2025.
Where's Mr. KP Bhattacharjee?
My lord, I not seen him around.
Are you gone for lunch?
By now, my lord, I think he must have had twice already, my lord.
Yes. Yes. What do you don't understand? What's
No, my lord,
not
it is for
Where's
him to
Mr.
explain.
Bhattacharjee?
It is for him to explain, my lord.
No, have you been paid any amount?
Yes, my lord. In fact, I had.
What is the outstanding amount you say is undisputed?
Yes, my lord. I have, my lord, previously supplied a chart, my lord, which I had prepared.
But he's not here. Let it.
Yes, my lord.
Yes, Mr. Shulai, you have paid.
Lordship, I am not aware who is bringing this matter.
KP.
Now pending amount 49 lakhs.
Yes.
Amount.
I am saying it's 49 lakhs. Now, what they have said in the affidavit, I could not understand, my lord.
And disputing the amount, that's the only thing.
They are not disputing, my lord, but I don't know what calculations they've given. In fact, on the last occasion, I had.
5%, what is this? He's not around. See, the court can't wait for counsel with the matters already. We'll have it when?
Not anytime next
week. Due to absence of the state counsel for the state respondent in this matter next week.
Deep.
Under 12.
Yes.
May it please your lordship.
Under 12 and 13.
Lordship, this is very limited prayer, lordship. It can be disposed of today, lordship.
Why? Why
It's
limited prayer?
Lordship, the prayer is that to grant one increment, lordship. I was denied one increment, so it was, and it is a settled law, lordship. I am entitled to get the one increment.
Law.
Lordship, the
Settled law, is it as per your service right?
no, your lordship. Settled law.
Where is that?
Lordship, I'll just rely on one decision of the Honorable Supreme Court, lordship.
Yes, Dr. Mosi, what's the matter about?
It's about only one increment, Lordship. I was working in the Director General of Assam Rifle, and I am retired in the year 2021.
Oh,
So
you're
before
saying in this matter, you earn 1 day prior to retirement.
Lordship.
Have you filed a presentation?
Lordship, yes, Lordship. I have
been
filed.
rejected.
Yes, Lordship. And they are claiming that, Lordship, I am not.
Then we'll have to hear it.
Next time. Next week.
Yes. On the prayer of the control parties, yes, next.
Same order for item number next, Lordship, 113.
115? 115?
My lord, before my senior colleague starts, my lord. My lord,
Who's
this
senior?
is...
You're senior or he's senior?
He's senior colleague to me, my lord. He's senior to me in profession. My lord, this matter was assigned to Mr. Momin, Adaya Momin. So we have just received the file this morning. So we'll need some time to go through prepare the matters, my lord. I'm praying for some...
How is he? He's recovering?
My lord, I've spoken to him. He is recovering well. So probably by December, he will be in a better state. He'll be joining next
How
year.
a young person gets stroke? Very strange.
And Mrs. Bhattacharjee also had a stroke this morning.
Who?
Seema Bhattacharjee, my lord. She is taking she's on treatment in Daygrims, my lord.
Oh.
We have come through a very bad, tough time in the panel, my lord.
Achha. The condition is...
My lord, we are not aware much because we just got through phone information, my lord. So we have not visited. So probably after the court hours, we will go and visit her, my lord.
Too much stress on the panel lawyers. It's on the lighter side.
Yes. All post-COVID, a lot of these things happen.
Yes, Lord.
On the pre-MSR, only this is matter for 2 weeks. Yes.
116? 116?
But here again, Madam Bhattacharjee was appearing.
Was it appearing?
Yes.
Oh, yes. Then they have to do something, yes. As the conducting council or the state council, as a council, we have to respond to state to be unwell just after 2 weeks, yes.
17? 117?
Yes. Who's the petitioner?
Mr. Pakinten, your lordship.
Who is Mr. Pakinten?
A. Pakinten.
What's the matter about?
Your lordship, it's a compassionate application for
appears they have a
compassionate
petitioner.
appointment.
Yes, over 2 weeks, yes.
Much obliged, lordship.
119?
Lord, this matter pertains to non-consideration for promotion. There are 2 criminal matters pending, 2 criminal trials pending against the petitioner and 2 disciplinary proceedings. I'll just try and make it as short as possible, your lordships. Lordships, kindly have page 24 and extra 1.
Yes.
So, Lord, on 1st December 2010, the petitioner at serial number 23, upon the recommendation of MPSC, was, my Lord,
one serial number 23.
23, my Lord.
Yes.
Was appointed to the post of, was appointed as probationer to junior grade of MCS.
Right.
Meghalaya Civil Services, my Lord. Subsequently, my Lord, at page 26 and extra 2, notification dated 6th April 2011, upon completion of the training, my Lord, he was inducted into service. Serial number 22 is the petitioner, my Lord.
Yes.
Now, during the course of his service, my Lord, your lordships will see at page 29. This is dated 14th of March 2016. There was an incident, my Lord, when he was when he was posted as BDO Jirang, my lord, one police officer, my lord, committed suicide, my lord. And he was, my lord, implicated in the matter as for abetment, my lord. So this was the information, my lord. To
That is in 2016.
2016, my lord.
Yes.
So he was taken into custody. Thereafter, he was placed under suspension, my lord, for a long period of time.
He was in custody from 7th October 2015 till 9th March 2016.
Yes, my lord.
That means not implicated. He was. Yes, anyway.
Yes, my lord. At that point in time, it was under 302, my lord. It was alleged, my lord. So pursuant to that, at page 30, my lord, he was placed under suspension.
Yes.
And on the basis of this FIR, my lord, now your lordships will kindly have page 58, annexure 25.
Yes.
So, my lord, on 25th July 2018, DP was drawn against the petitioner, my lord, on the basis of that particular FIR, my lord, for abetment of suicide of the police officer. 59 is the article of charge, my lord.
Yes.
Now, in the meantime, my lord, during pendency of the trial in this particular FIR and also the DP, my lord, at page 71, your lordships will find a second FIR, my lord. At page 71, annexure 26, there's a second FIR, my lord, when he was under suspension. This is dated 10th of, typed copies, my lord, at page 72, dated 10th of July 2018. This FIR is against unknown persons, my lord, for, my lord, planting a bomb outside MPSC.
Planting a bomb?
Yes, my lord. It might read, my lord. I'll just read page 72, my lord. It reads, my lord, in reference to the above, I am to inform that today on so-and-so at 7:45 AM, the office chamber of Secretary MPSC was found to have been set on fire by unknown miscreants, damaging the furniture and fixture, computer and electrical appliances, etc. in the room. That as reported by one of the chowkidar in the building, namely ineligible Lamare, he saw smoke emitting out of the window of the room facing the entrance. As he went towards the first floor to check, he came across two unknown persons running down the staircase from the first floor, and he tried to confront and apprehend them. They pushed him down the staircase, and the unknown persons managed to fled the cemetery point, Centenary Point and Uttarat Singh Stadium. That the act of these two unknown miscreants who have been committed the arson and damaged the government property approximately worth 10 lakhs is to intimidate the office and office staff of MPSC for carrying out the official duties. In this regard, I am to request you to take on investigation to the matter.
How was he connected to this incident?
Well, unknown. Unknown. The only thing is, from what I have been told by this person is that his cook was found, my lord, amongst the crowd standing and watching what is happening there, my lord. That is the only connection. His cook, my lord, who was a cook in his house. That is the connection, my lord. Now, my lord, pursuant to this, my lord.
Where is his reply to show for?
Now, my lord, pursuant to this, upon this second FIR being filed, my lord, lodged, page 89, my lord, another DP has been drawn. Page 89, annexure 33.
But they can't just connect you unless there's some,
Yes, my lord, I'm undergoing trial, my lord. I'm facing the trial.
Credible information.
Yes, my lord, I'm facing trial. Now, my lord, at page 89, annexure 33, on 17 March 2021, on the basis of the second FIR, the second DP was drawn against me, my lord.
That time he's still under suspension?
Yes, my lord, under suspension.
Who's the inquiry officer in the earlier DP? Is it the secretary of the MPHC?
No, my lord. It can't
Who's
be.
the inquiry officer was appointed? Any idea? Anyway,
yes,
just roving.
But it's got nothing to do with MPSC, my lord.
No, I mean maybe the officer or something who was getting, maybe was in, anyway. Yes.
Now, my lord, so the second DP was drawn, my lord, at page 89 on 17th of March 2021. And the article of charge at page 90, your lordships will see, on the basis of the second FIR.
Yes.
Thereafter, my lord, I'll straight away take your lordships to page 100 and...
See, page 93 is from the EIG saying that come to light the judge Pasa and so on in one incident. She was arrested again.
Yes, my lord.
Arrested. He was taken to custody.
Taken to custody, my lord.
And how many days he spent in jail? Anyway.
Released on 20th of October. So July to October 2018.
From July to October is in custody?
Yes, my lord. At page 93.
First time was from 15 to 16. Now July
2018 to October 2018.
Quite a colorful character, I mean.
My lord.
Yes.
It appears from the record. Now, my lord, now coming to the main part of this matter, why I am before your lordships may kindly have page 115.
Yeah.
115. This is notification dated 23rd December 2021. Now, my lord, middle of the page at C. The person promoted at C onwards, my lord, from C up to H. These were all junior to me, my lord.
Yes.
During appointment, my lord. Subsequently, again, my lord, at page 117 on 1st April 2022. After the first promotion, my lord, then he was reinstated, his suspension was revoked and he was allowed to join service, my lord.
After his first?
After this first promotion, my lord, page 115.
So after he was reinstated when?
Reinstated, my lord.
Have you made a list of dates here?
But there's a list of dates, but I could not find that reinstatement, my lord. Therefore, I had sought for instructions. He was reinstated on 25th of July 2022.
He said first promotion is 23rd December 21.
Yes, my lord. So after that, second promotion also happened.
Reinstatement was a reinstatement order.
Yes, my lord. So page 117 is a second set of promotion. Where
Was
the
the reinstatement order?
reinstatement order is not on.
Is it there in the affidavit?
Lordship, yes. In our affidavit at page 49.
I don't have a page 49 of your affidavit. That's all. I don't have a page 49.
Maybe somewhere.
Or is pending the DP?
Okay, maybe the page has just come out. I've just so my lord, he has
Yes.
so he was reinstated. His suspension was revoked, my lord, and reinstated, my lord.
Yes.
Now thereafter, at page 121, your lordships will find the gradation list being prepared, my lord, by the department, by the government.
Where are you now on the gradation list?
Yes, my lord.
You have to do all these other people now.
Now, my lord, 122 it starts from 122, my lord. The first one is the first grade is head of department scale, page 124, senior scale, my lord. Senior scale, and thereafter those who have appointed subsequently, my lord. Now, my lord, pursuant to this, I made a representation, my lord, at page 133, annexure 38, regarding his promotion, my lord, for consideration of promotion, and that he was never considered for promotion.
What stage the DP? Both the DPs? Mr. Shulai?
Lordship,
Bring a status.
I'm not. I'll have to
just allow me. I'll just come to the law. So, my lord, several representations were made, my lord, from page 133 onwards up to page 144. That is annex 38 to 44. No response, my lord. No response. And then at page 146, my lord, dated 30th August 2024, my juniors from the gradation list, they also have been promoted.
Junior scale?
Yes, my lord. From the junior scale, where in 22 I was number 1, my lord, or 23. Now even those juniors also have superseded me, my lord. Page 146 is one order, my lord. And thereafter again I made my representation at page 149. Now, my lord, the affidavit of this, the state have filed the affidavit.
No, one thing I want to know. What stage is the DP? Concluding, in the middle, midway, beginning?
Lordship, I'll have to.
We have to know.
I'll have to take instruction, your lordship.
But when the DPCs were held, was his name taken into consideration at any point of time?
No, my lord. That's why I'll just point out the affidavit now, straight away, my lord. Affidavit filed by the state. If your lordships may kindly have affidavit filed by the state. Lordships may kindly have page 3, para Roman 2 onwards. I'll just read these 3 paragraphs. So this will sum up the stand. Roman 2, my lord, it reads at page 3 that the petitioner was placed under suspension in the year 2015 due to his involvement in criminal case registered as Nongpo PS so-and-so under section 306 IPC, later charge sheeted and further implicated in Sardar PS case number so-and-so involving serious offences including arson and criminal intimidation. As per settled service jurisprudence, this is what they say. An officer under suspension and facing disciplinary proceedings and criminal proceedings is not entitled to promotion or inclusion in promotional exercises. This is my case, my lord, that they have not been considered, my lord. Is not entitled to promotion or inclusion in promotional exercises. That the delay in consideration of promotion and continuation of suspension were due to the pendency of these criminal
MCS service rules?
Service rules.
No, what stage? Just find out, Mr. Shulai.
I'll find out, your lordship. What are the stage? What are the
Find out
stage?
what stage of DPs are criminal trials.
I'll find out. Yes, your lord. Both the criminal trial as well as the.
As per the order, my lord, what I have order sheets. As per the order sheet which I have of May 2025.
Yes.
This is in one of the DPs, my lord. They have only appointed the presenting officer, one TG Momin. If I may just
in
hand.
second DP.
Yes, my lord.
What about the first one?
My lord, I have to figure out whether this is the first DP or the second DP, my lord.
Let me have instruction, lordship, relating to the.
Link.
No,
We
the
can't
point-
come to any conclusive or any definitive.
No, my lord.
finding
Now I'll come to the law point, my lord, regarding sealed cover, my lord. That is where I want to come.
I get it where you're
Yes.
progressing to. The only thing is that, what notwithstanding any other circumstances, even if the department proceedings pending this and that, it doesn't mean that it should be left the wayside.
Correct.
Yes, case should be taken into consideration, kept with seal cover, depending on its performance and other ECR recommendations. not getting valuable assistance.
Their own notification, my lord, of 2024, notification by the government regarding timely conduct of DPC, my lord.
That is made to be flouted.
No, my lord. No, my lord. In the affidavit, they say we are not even entitled to be included in the process, in the DPC process.
See,
what their own policy says.
They have not said as per rule, as per civil jurisprudence. How can you say? How can you attribute civil jurisprudence as per settled civil jurisprudence? And also such an what kind of statement is this?
Exactly, my lord. Exactly. Now their own my lord, notification provides, my lord, that report of cases and criminal cases. It provides, my lord, there are also cases which comes before the DPC where there are court cases and criminal cases that are pending against the incumbent government servant whose promotion is under consideration. In relation to this, all department heads should bring the latest status and details of any such case before the DPC. In my case, they don't even send my name to DPC, my lord. They say you are not even entitled to, my lord.
So they'll have review DPC, then that's the only thing you can ask.
Yes, my lord.
Yes. You bring a status.
Lordship, yes.
Yes, in the course of hearing, it is this court feels it necessary to obtain the status reports with regard to criminal trials pending as a petition, as well as the status of the departmental proceedings. Next stop, Ms. Anisha Island AG to produce required information on next date.
Lordship.
When we list it?
After a week, after 2 weeks, your lordship.
Anytime.
After 2 weeks.
No, but that's the only thing is they're asking for. Actually, only that, you know.
Lordship will have to see, your lordship, because the fact remains that some of the junior have been promoted, have been.
Doesn't matter.
Lordship, because
matter.
if
Suppose
that
in the end, in the
final
end,
directed,
maybe before it retires, when the criminal trial is concluded,
lordship, because
and then when that they find that maybe he's not, he's exonerated.
Those people,
just suppose situation, right? Then he'll be entitled to whatever financial benefits as well.
Because those people who have been given the promotion will be affected, your lordship. Because they were not before, your lordship.
After, suppose have a review DPC and they see that yes, now it's too early.
They have to consider.
Yes.
Apply, your lordship.
123.
Wait, please, Lordship. Lordship, this is the matter related to VC of village.
I don't think we have time today, Mr. Lindo. Sorry.
No, the case is not maintainable. We have already indicated in our affidavit they have fraudulently obtained all the signatures, and we are
no, not your Lordship.
And
the
they have
entire crux of
insufficient
the matter,
proof.
Your Lordship, there has been multiple resignation due to existence of certain VEC. So it so happened, Your Lordship, as per the affidavit filed by the private respondent, there are many women involved with resignation. So they get elected again upon resignation of given problem.
The facts are highly disputed in this matter. It would not follow.
You are appearing for whom?
I'm representing the private respondents, my lord.
I'm appearing for the state, my lords.
Okay. Yes.
So, Your Lordship, the entire crux of the matter and the prayer we sought for is for a fresh election to the VEC so that it will be sustained for the terms of the 3 years.
What VEC is already in place now?
Yes,
they were always in
Your
place,
Lordship,
my lord.
no, Your Lordship.
They were always in place.
See, you can't have a submission. He submits and you interject and the private one interjects. This, what do you have to say?
No, Your Lordship, in accordance my pleading, Lordship, the document relied. There has been multiple resignation during the existence of the VEC.
So what do you want the court to do? To have a roving inquiry?
Your Lordship, I want fresh election in the diameter so that with a strict direction.
The facts are correctly placed and there's some illegality, some rights violated,
Yes,
then you
Your
see the schemes, but then we can call fresh election. Just on a statement that there's been what they call it, interpolation and wrong entries, we can't ask for free election unless there's. In other cases, we call for inquiry. The BDO is a correct authority to ascertain this.
Yes, Your Lordship, but there are certain allegations as well which they say about forging of certain documents. But we have with us also, Your Lordship, certain documents.
I don't want to sit here and see whether the documents are forged or not.
Yes, Your Lordship. But they are raising the allegations on that.
It's a writ court, Mr.
Yes,
Lindo,
I'm aware, Your Lordship. But the main reason is that, Your Lordship, the implementation of whatever work implemented under the scheme, Your Lordship, it's not implemented in a proper manner. Because initially, by the time the terms end, they would change all the members. And that will bring in all the irregularities, Your Lordship. And
see a prayer? Oh, is that a PIL?
It's at page 9, Your Lordship.
You should have an order doing that in the event the current VC returns was.
Your Lordship, but I've made a prayer also to quash the entire, the order dated 24/5/2023 and 28/8/2024, which was passed.
But after 1 year and 2 years they have come, Malad, challenging that order.
There's been many irregularities still present, Your Lordship.
No, we'll hear you. Next week, next week. Hope next week we have enough time. Some dislocation.
But lots of sentences. But the interim order in those SOP matters.
Oh yes, till tomorrow.
Because by the time matters are heard, judgment delivered, it may take some time. And the 3 fresh matters, 5, 6 and 7 in supplementary list.
5, 6, 7, same order. Even the
remaining
debt
matters.
matter also.
Can we until further orders?
Yes.
Until further orders.
Until further orders.